Hi, Sam Bradley. Another video today on collaborative law. Collaborative has been marketed as a less expensive, faster, easier, less stressful way of getting divorced. Undoubtedly, that has happened. Let me explain the process. You don't go to court. You each have your own attorney in a four-way process that they call transparent. I don't know what that means, as I've said before, but you can ask them what it means to be transparent. I don't think it is. I think it's more opaque, actually. But you sit in a room with them, and the first session is, which you pay for, an explanation of what collaborative law is all about. You're each paying your own attorney, and theoretically, they are keeping your secrets. Now, while you're in your collaborative sessions, you're supposed to be open and honest, and if somebody hears an untruth being spoken, they're supposed to go, oh, yep, no, that's not quite right. Please correct this. But of course, there's no record to correct as there is in the courtroom, so one spouse can go online or an attorney can go online. Let me give you an example from my case. Mine was collaborative law used after a trial and after an appeal. It was at the suggestion of opposing counsel, Jeffrey Kaufman, from my ex-husband. In retrospect, a really stupid idea. But I learned a lot about collaborative law. And I learned that there's nobody taking notes, that we're living in a very non-technological place when we're talking about collaborative law. Somebody is taking notes by hand about what's going on, then they send it out to everybody. And if they're wrong, it is upon the client to fix them and then send it on out to everybody. It's a huge waste of time. Otherwise, it goes down as gospel. That so-and-so said he would give this amount of money, or this one said this about custody. And if that's not, in fact, what your understanding of it was, you don't have a record other than an attorney who has been multitasking. Why are these sessions not videoed and audio taped? If they're not, you don't have a legal record or a foot to stand on when you go there. They don't want them taped for reasons you will come to understand. They keep a lot of information from you. But let's go back to my own case as an example so you can see. Ron Romines, Michael Lowy, both of them have taught ethics. Both of them have been long-time collaborative attorneys in Palo Alto. And as a matter of fact, Michael likes to credit himself with bringing collaborative law to the United States. I think it's because of his anthropology background, and he studied tribal law. And somehow he brought this over. You can research him if you'd like. So it's interesting to me that Ron Romines decided to send private emails written by his client to opposing counsel. Is this allowed? Well, hell no, it's not allowed, but they did it anyway. We didn't know about it. And then they'd come and charge us their hourly rate and tell us we have to be honest and ethical, and what a great process collaborative law is. Meanwhile, they're sending these private client emails back and forth. How do I know this? Because eventually I terminated Mike and got my file, and there in the file was an email from one attorney to the other saying, as we discussed on the phone, here's the emails. And there they were. And I've asked them about that. Did you get permission? No, they did not get permission. Nobody's responded. They know they're wrong. But this is what can go on. These are the dangers. The dangers are that you've got a power imbalance. You've got attorneys who know the law. They have no judge who's going to say, okay, counselor, I don't want to hear any more of this because you're wrong. Bring me evidence. Nobody asked for evidence. Every time I would try and bring up evidence in collaborative law, Mike would say, actually, he'd put his hand on mine and go, and let the process work. I was never quite sure what that meant. Did he want the process to dress up and go somewhere, put on a nice little hat? Or was the process female? I don't know. But, Mike, the process wasn't working, especially not while you're lying behind our backs. and pretending that you're ethical in front. This isn't the only thing that's wrong, that they did these things in my case. Across the board, you've got a lot of problems in collaborative law because lawyers lie. They want to get things done in an expedient manner for themselves, folks, not necessarily for you. They're bringing in outside, I like to call them outside agitators. In my case, Mike went ahead and without my permission hired a real estate attorney. Why? So that we could use the money that was owed me by the court, which the court told me I was owed a money judgment, so that Jim could buy a house. Oh, folks, this is a true story. This is collaborative law. And these are friends of Pauline Tesler, who likes to market and go around and say, oh, look how great it is. But Pauline Tesler's clients call me. And I have spoken to an attorney in Marin County who gets the clients that leave Pauline Tesler. And she's the guru, or she likes to think she's a guru. She based it all on Jung. So folks, if you think that this is a good way of following the law, going ahead and getting your divorce, go ahead and look into it. You'll see an awful lot of it. Let me tell you, they're making a bundle, they work less, and get more money. Think about it. Follow the money.